Hi, Derek here of McKenzie Friend Consultants. Welcome back. In my last video, I covered the stark truth behind parental alienation and how Cafcass and the court deal with it. Well, actually, in most cases, how they fail miserably to deal with it, causing significant long-term damage to your children and to you, the target of parental alienation. There are a few success stories, however not enough, as Cafcass are so ill-equipped to deal with it, and as a result, the court are powerless to act on parental alienation. Well, enough is enough, and in today's video, I'm going to cover how to counter parental alienation and increase the possibility of the court actually listening to you. Now, just before we get into the details of this video, I will suggest that if you find this video helpful, then subscribe by hitting the button below, as you'll probably find my other videos useful. As a quick reminder, let's begin by looking at how parental alienation is defined by Cafcass. Cafcass defines as when a child's resistance to one parent is not justified and is manipulated by the other parent. The truth is that parental alienation is the resident parent, which is typically, but not always, the mother, demonising the father in front of the children, which over time turns them against their father. Cafcass, the court advisors, have their child impact assessment framework, which includes a guidance for parental alienation, which is totally flawed and unfit for purpose. Experts such as Dr. Miller and eminent psychologists will tell you that parental alienation is an evidence-based science, and it's important to distinguish between science and speculation or ideology. Your voice will not be heard under the normal process, and if it is, it'll be way far down the road for the court to make any meaningful decision. It's time to stand up, and for the sake of your children, take action now, and the earlier we start, the better. Step 1. This step can be taken even before you make your application to the court. Your ex, who is on a mission, is either going to listen to pleas for contact with your child, but they might just listen through mediation. You have to try mediation, or at least go to what is known as a MIAM, Mediation Information Assessment Meeting, before you can even make a court application. Therefore, why not use this opportunity to see if the mediator can help initiate contact with your children? It's a long shot, and as Dr. Miller states, with alienators, you're dealing with 3 types: borderline personality disorder, narcissist personality disorder, or sociopathic personality disorder, or a combination of all 3, and as such, they're unlikely to listen to reason. So you move to step 2 when you make your child arrangements application to the court, and what is known as a C100 form. You have to state if there is any form of domestic abuse or child abuse. You tick both boxes, and also submit what is known as a C1A form, which is for allegations of harm and domestic abuse. And this is where you state that there is parental alienation and that your children are being emotionally and psychologically abused, and that you are the target of parental alienation and a victim of violent abuse, as your ex is purposely trying to cause you harm. Step 3 is your interview with the Cafcass officer. Before your first hearing, Cafcass have to submit what is known as a safeguarding letter to the court, which basically informs the court of any safeguarding concerns or risks for your children. As part of the Cafcass process, they will arrange a 20 to 30 minute telephone call with each party. This is where you explain what is going on, and you discuss your ex's parental alienation and the significant damage that is causing your children and you. You should ask Cafcass for their help with this and how it can best be dealt with as early as possible in the court process to prevent longer term damage. Now, this may be a little tricky, and I'll suggest that you watch my video on your initial call with Cafcass first. The problem is that Cafcass hear this regularly and are not very open or receptive to the idea of parental alienation. They believe they are the experts and will only consider parental alienation as a last resort. How wrong can they be? It is just far too easy to listen and believe your ex's allegations of domestic abuse as a reason why your children don't want to see you, and then far too easy to recommend to the court that you have no or little initial contact. If you feel that the Cafcass officer is taking you seriously, then you may wish to ask that due to the complexities of parental alienation, could they consider recommending a fact-finding hearing to the court to establish if indeed there is parental alienation. But don't hold your breath. You'll find out the recommendations when you receive a copy of the Cafcass safeguarding letter to the court. Step 4. If you do not get the support of Cafcass, or feel that the officer is going to recommend a fact-finding hearing, then to elevate the parental alienation issue, you should consider making a further application to the court. In that application, you ask for directions at the first hearing for a fact-finding hearing to consider the parental alienation by your ex due to the significant ongoing harm to your children and how it is wrecking their lives. And this is also domestic violence to you, as the intent of the behaviour is to deliberately harm you. The court will therefore have to take your application seriously. I am normally opposed to fact-finding hearings as they can slow down the court process by 4 to 6 months, but in these cases it is the only way you will be heard. Step 5. At your first hearing, the court will review your application and discuss your allegations of parental alienation. They will ask Cafcass for their view. Cafcass may support your request, but they are just as likely to suggest that they initially conduct a Section 7 report so they can provide a further assessment of the situation. Now, this may help, but as explained in my previous video, Cafcass only consider parental alienation as a last resort after they have eliminated anything else, and their tools for assessing this are flawed and not fit for purpose. This becomes a tricky situation, but you must stand strong and politely explain to the court that with all respect, that due to the complexities of truly assessing the presence of a parental alienation, it really needs the experts of a psychologist to conduct what is known as a family psychological assessment, and that you request that the court orders this. The judge will be in a quandary. You are, however, being listened to and taken seriously. The judge may agree to your request and direct that there should be a fact-finding hearing, and that prior to the fact-finding hearing, a family psychological assessment conducted, which would be great. But at this stage, he is just as likely to order that there is a Section 7 report conducted by Cafcass, which will be reviewed at the next hearing, and only then will the court decide the next steps. Step 6, the next hearing. If the fact-finding hearing was directed, then great, you have been heard. The author of the family psychological assessment should attend the hearing, and this will prove if there is a level of parental alienation or not. If there is, then the court will hopefully make decisions regarding how to best to deal with it for the emotional well-being and safety of the children. I will suggest that at this stage you may wish to request that the court orders a change of residence to you. As the other party will almost certainly object to this, it is highly unlikely that the court will consider making a change until the final hearing. But you hope that the court will at least direct that contact with you restarts immediately and your ex will be directed to ensure that it happens. If the fact-finding hearing wasn't previously directed, then the hearing will be a directions hearing to consider the findings of the Section 7 report. As expected, if the Section 7 report is vague, inconclusive, or even worse, does not consider the presence of parental alienation, then you should object and insist on an independent expert to complete a psychological family assessment. If the court at this stage directs the assessment, then you're back on track. If not, we go to the next step. Step 7. You make another application to the court for directions and consideration for a family psychological assessment, giving your reasons as to why you feel that the findings in the Section 7 report were inconclusive or flawed. The court will hopefully take your request seriously and grant you the assessment, and you are then back on track. Now, I didn't say it was going to be easy, but we have to fight this nonsense in the family court for the safety and well-being of your children and yourself. If you'd like assistance or have a chat about your case, then go to www.McKenzie Friend Consultants with an s.co.uk and book your free consultancy with me. That's it for today. If you find today's video helpful, then hit the subscribe button below, as you'll probably find my other short videos useful. Bye for now, until my next video.